Hey guys, Chicago workers' comp lawyer Scott DeSalvo here, and in today's video I wanted to share a tip, tell you a little story about what happened to a client of mine. Well, he eventually became a client, but a guy called me up. He got hurt at work. He went to his family doctor. Family doctor referred him to an orthopedic doctor. He had a back injury, and both his family doctor and the orthopedic doctor wrote a note saying that he should do light duty, right? So when you get a off work note from a doctor, it can either be a note that says you can't work at all, or it can be a note that says, light duty, no standing or lifting more than 20 pounds or more than 10 pounds or things like that, right? This guy had a very physical job, and so actually the family doctor told him not to work at all, and the orthopedic doctor gave him a light duty work note where it was like no sitting and standing repetitively and no lifting above 20 pounds. Well, this guy worked in I think it was a factory, and he had to lift more than 50 pounds basically all day. And the main reason he called me is that the company was calling him and saying, hey, you got to come to work, you got to come to work. He provided him with the off work note, and they still wanted him to come to work. They actually threatened his job. They told him, if you don't come in, we're going to fire you. We don't do work comp here. That's what they told him, something like that. And I'll tell you what I told him. The way workers' comp works is, if you have a off work note or a light duty, modified duty note from a doctor, and your job requires you to do things that exceed that modified duty, then it's a really bad idea for you to go to work. The main reason why is, like I've said in other videos, you get one body in life, and if you go back to work and don't follow your doctor's orders, you could easily hurt yourself much worse, right? So I don't like to see my clients get hurt at all, but you certainly don't want to get hurt worse. The name of the game here is you ought to follow your doctor's work restrictions, and the company can't force you back to work. They can't, they're not allowed to call you up and say, we don't care about your doctor's note, we want you to come in and do it, right? And if they do that, there are penalties in workers' comp. So we can get a case filed and get in front of the arbitrator and actually get them penalized for that, for doing that, because that's dirty pool. But there's one exception, right? So if you watch some of the other videos that I've shot, you know that the company can hire their own doctor to examine you, not to treat you. You get to pick who treats you, and I rarely or never recommend that somebody treat with the company doctor. But the company, the workers' comp insurance company, can hire a doctor to examine you almost as many times as they want to, right? But your doctor directs your treatment, so they can easily basically, if it's a scenario where your doctor says, Jim, stay home from work, and the company doctor says, no way, he's 100% ready to go to work, he doesn't need to be off work, that might be a situation where me or another workers' comp lawyer might tell you to try to go to work based on how you feel, right? That's how I do it. So if I got a treating doctor who says don't go to work, I'm inclined to follow that and not follow the company doctor thing saying go to work. But if there's a conflict and my client feels good and my client feels like they're ready to go to work, then I'll sometimes tell them, look, we will get some credibility with the judge and with the insurance company if you try to go back to work, and that if you can't do it, report it, and you can always get another off work note, and then at least you tried to go back to work in light of the conflict. And in a conflict like that, we're much more likely to go to court and win and get all that medical care and get that TTD, that lost wages paid for you because you tried to go back to work, but you just couldn't do it. So I hope that makes sense. I mean, the general rule is if you have an off work note from a doctor, you are 100% within your rights not to go to work. But if there's a conflict between the company doctor and your doctor and you feel up to it, it doesn't really hurt your case to try. But if you're not able to do it, you got to get back to your doctor right away, report to the doctor what they had you doing, how it made you feel, and what happened, right? Get your attempt to go back to work documented, and then get a fresh off work note and honor that one, and it puts you in your best position to win the case and get your benefits. Okay. I probably should have said good morning at the beginning of the video. Good morning. Have a great day, and thanks for watching. Give me a holler if I can help. Take care.